just going to give it another moment for everybody to load up, and we'll get started. Technical difficulties, I'm sure everyone understands. So for those of you who don't know me, I'm Michael Ettinger from Ettinger Law Firm, and our practice is limited to elder law estate planning. In fact, that's all we've been doing for over 30 years. I'm the past president of the American Association of Trust, Estate, and Elder Law Attorneys, and also author of the book, Elder Law Estate Planning, which, if you like, you can get on Amazon or Kindle. So this is our weekly Zoom side chat. I want to thank you all for listening in. Thank you for your patience while we overcome our technical difficulties, and they are overcome, thankfully. I did get a new microphone. I hope it's easier to hear me, and I think I'll speak up to boot. So today, what I'd like to do is give a full elder law estate planning seminar together with slides. This is a seminar that I have been giving for over 30 years, and it's not something I purchased. It's something that I wrote based on my own experiences. And somebody once asked me, how long did it take you to write that book? I said, well, it took me about 25 years. I had to get the experience first. So I want to just cover a few housekeeping items. We do estate planning and elder law. We're going to go into that, but I would like you to know we handle every type of Medicaid case. We do all types of estate planning, but not everybody knows we handle Medicaid applications. We've been very busy at Ettinger Law Firm. We're doing remote trust signings, so we have all the technology down, besides today. What happened today was I unplugged the phone because I didn't want it to ring during the webinar. And when you unplug the phone, it unplugs the computer too. So I had to reboot the whole thing. Of course, I didn't know that, but I know it now. Other things I want to touch on, I'll mention today some new rules for getting Medicaid for home care. I want to advise, and I'll remind you later, this seminar is going to be given every Wednesday at 7 p.m. starting from now on. So we'll do the Zoom side chat at 3. And for friends, relatives, family who you want to send this information to after we're done, they will be able to watch it themselves any Wednesday at 7 o'clock while we're staying at home. So now we're really going to go high tech, and we're going to share the screen. And it looks like this. So I can see you, but I don't see the screen naturally because I have to go back and get that. So bear with me a moment. I have to go into another program. And there's the screen. It's up. Minimize that. Share screen. Click on the screen. And voila, we have the screen. So the name of the seminar is 4 Major Reasons Why Trusts are Preferred Over Wills for Seniors. And it starts with just an overview of what is elder law estate planning. So we're an elder law estate planning firm, but what is it? Well, elder law estate planning, it's a niche area of the law, and it combines elder law with estate planning. And this is what the middle class need. Elder law, getting Medicaid benefits, planning for disability, estate planning, who gets it after you're gone. Since '91, which is the year we founded Ettinger Law Firm, so it's our 30th year this year, tens of millions of people have set up trusts to save time and money in settling the estate, avoid guardianship if they become disabled, avoid having their personal and financial matters made public, and reducing the chance of a will contest. I'm going to go back to that. Excuse me. There we go. And you keep control in the family and out of the court system. So I often say, estate planning is all about keeping control. You're taking back control from the courts and government. You're giving it to yourselves and your family and your children, so that if you become disabled, you don't have a court stepping in. We're going to get into the details of that. So the first reason why we use trusts instead of wills is that wills don't provide for disability. So a trust has lifetime planning. Will starts at death, but the trust starts while you're living. So you can put in, you could say, I'm in charge now, but if I become disabled, I need so-and-so to step in. So will is no plan for what happens if you're sick or homebound or disabled. And a trust is a plan for all three phases of your life. It takes care of you while you're healthy and competent. You're in charge. This is the revocable living trust. It allows for you to choose the person you want, or it could be even 2 people or 3 people to handle your affairs if you become disabled. And then it says what happens after you're gone. So what happens if you don't have a trust and you only have a will? Well, you risk guardianship proceedings. Now today, with advances in medical science and better nutrition, the chance of any of us becoming disabled is about 50%, usually later in life. And without a plan, the state has written a plan for you. You may have heard of it. It's called guardianship proceedings. So if you don't have a plan, there we go. Okay. Screen sharing is stopped and the windows closed. Okay. Terrific. Okay. So we have to go back and get our screen again. And there's a way to do that. Okay. There we go. It's canceled again, keeps canceling. Okay, so what we're going to do is we're going to reboot. My fault, I plugged in the phone. The phone is still rebooting. Once it reboots, I'll be able to put the slides back up. But in the meantime, you can follow along with me if you have your own slides. So if you don't have a plan, the state can appoint a legal guardian. Who are they going to appoint? Actually, we don't know. It could be anybody. Somebody who the judge decides they want. You would think they would pick up your sons and daughters as your legal guardian if you became disabled, but a lot of the judges fear sons and daughters have a conflict. What's the conflict? They spend it on you. It's coming out of their inheritance. So I like to pick somebody independent, usually a local attorney. I've certainly been picked as a legal guardian, but you lose control. And we're going to talk about some of the issues there in losing control. But the first thing is, guardianship, which is increasing risk because more and more people eventually become disabled. Guardianship is expensive. It's time consuming. What happens is a judge will appoint a court evaluator to meet with the disabled person, determine the nature and extent of their disability, prepare a report to the judge. The judge is going to want to meet the disabled person, usually by bringing them into court, but if they can't, the judge goes to the facility and makes the judge's own evaluation. Everybody is, brothers and sisters are all a part of it. They may each want to have their own lawyer. There's very often quite a few lawyers in a guardianship proceedings. And this could take a lot of time, be a tremendous expense, and all avoided, with a trust. But the other thing is, a legal guardian has limited access to protecting assets. So what happens if somebody becomes disabled? Well, if your people are in charge, they're going to meet with us, and we're going to advise them of the various ways you can protect assets. You can transfer assets. You can different ways of spending assets that are exempt from Medicaid. But the legal guardian isn't going to do that. The legal guardian exercises the state's plan, which is what? Spend it on you till there's nothing left. So we like it. You take back control. You have your sons and daughters. Not everybody has children. It could be nieces and nephews, but you have the people you trust in charge. And obviously, the people you trust are the ones going to act in your best interest. They come and meet with us. We say, here's what we can do. Do you know, under the Medicaid law, this is in my book, and it's also on my website under practice areas, you know, even with somebody on the nursing home doorstep, you can save at least half the assets if the family is in charge, because if the family is in charge, they have the right to move it. And under Medicaid, it's move it or lose it. So legally, you can move half, but it has to be your people in charge to actually move it, because the legal guardian is not going to, you know, gift assets to the children to protect them. The legal guardian can only spend the money on you. So I hope you get the sense that the first thing, or one of the most valuable things about a trust, it allows you to control who takes over if you become disabled. You know, you pick your people. They have asset protection options. They're dealing with your attorney, and they're working your best interest. The state-appointed legal guardian is, you know, a wild card. I wouldn't want it for myself. I wouldn't want it for any of my clients. You know, along the same lines, and this is a case that came up yesterday, so I want to talk about it. The second thing is, you know, as far as elder law, we're looking at something called an elder law power of attorney. And the elder law power of attorney is not the garden variety. You know, the standard form power of attorney is 3 pages. The elder law power of attorney is 14 pages. What do you think's on the other 11 pages? All the powers you need if someone becomes disabled. And there are about 50 or 60 powers that we use in the power of attorney that general lawyers don't use because they don't deal with this area of the law. They don't know the powers you need if you become disabled. So I call the standard form power of attorney that most lawyers use, we call that over-the-counter medicine. The elder law power of attorney is actually prescription strength. Well, if you become disabled, it's exactly the same as medicine. You know, if you need prescription strength and you only have over-the-counter, it doesn't work. And that's the same thing. If you're disabled and you only have the standard power of attorney, it's not strong enough. It doesn't work. In fact, it's so weak that Medicaid will not permit you to use the standard form power of attorney. If you have to apply for Medicaid, you need the elder law power of attorney. The main thing about the elder law power of attorney, it allows you to move the assets out of the ill person's name, because under Medicaid, it's move it or lose it. And as I said, even on the nursing home doorstep, you can save at least half, provided you can move it. So you have to have the power to move it. I want to tell you a story, something that happened yesterday that comes up. A client called me. You know, elderly parents, dad is in a nursing facility, mom is disabled, and they're panicked because they need to do some financial transactions, get access to dad's money, but dad thinks that only mom is on the power of attorney. Now, our firm did that power of attorney. I said, that's very unlikely. You know, we don't just put the spouse on as the power of attorney, because we know when people get elderly and we need to use that power of attorney, the spouse is also elderly. They may be disabled at the same time. So I said, let me look at it. So I pulled it up and I said, sure enough, I have, by the way, she couldn't get the power of attorney because the dad had it in the nursing home and she can't even get into the nursing home. So I pulled it up, that technical capability I do have. And I looked at it and it said, mom or daughter or other daughter. Now, it's an interesting point. Do you know that almost every lawyer writes the power of attorney, says mom first, daughter second. And if we had done that, they wouldn't have been able to use it, because daughter would have to prove that mom couldn't use it because mom is first, daughter is second. So as experienced elder law attorneys, the way we write this power of attorney, we say, dad says, if I become disabled, my spouse or my daughter. This way, if daughter needs to use it, she doesn't have to prove that mom can't. It's a huge issue. And this is why you want to get your power of attorney from an experienced elder law firm. It makes all the difference between moving and protecting assets, being able to do things, or being hamstrung. So I want to say that about the power of attorney. Other drawbacks of wills, you know, you're in court. And the executor cannot act until approved by the judge. You know, how do you get there? Well, you know, it takes time. You have to meet with a lawyer. lawyer has to prepare a petition to the court. In the petition, the lawyer has to allege and prove that at the time of signing that will, you're of sound mind, memory, and understanding. You were not under any fraud or undue influence. A few other proofs. I have to get that petition, serve it on the heirs, the potential heirs, and get proof of service back to the judge, and then wait for the judge to rule. Now, obviously this takes time, and you might be the client calling me and saying, well, look, we're 4, 5, 6 months into this. What's happening? I say, well, I submitted to the court. And the client says, well, why don't you call them up and see, where it is? I said, oh, I can't call them. They don't want to hear from me. If I call them, they'll take me from the top of the pile, put me at the bottom of the pile, teach me not to call again. When you'll hear from them? When you hear from them. Could be weeks, months, sometimes years. So you have no control over the situation. Extremely frustrating, and you're paying a pretty penny for the privilege. So I think it's well known, especially in New York, probate proceedings, especially in some of the counties, it can be costly, it can be time consuming, and very stressful because you don't have control. I'd like to tell you another story. This happened last year. So a client of mine, he was named executor on his father's will. His father died in New York, but he had a house in Virginia. So as executor on the will, the client contacted a real estate agent, listed the house for sale, found the buyer, and signed the contract. And then he sent me an email, said, Mike, could you probate the estate so we can go to the closing? I said, Brian, what did you do? You can't list the house for sale. You can't sign a contract until you've been approved by the judge. This is going to take 2 years. Wow. So we had to undo the transaction, pay all the buyer's expenses. Now my client, Brian, wants to rent the house. I said, Brian, you can't rent it because you can't sign a lease agreement. You're not appointed as executor. You can't go into a contract. So now he has a house empty in Virginia. He's carrying an empty house in Virginia for 2 years. It takes a probate in New York, and you have to do another proceeding in Virginia because that's where the property is. Do you know if his father had a trust, he could have sold the house the day after his father died, if he wanted to, obviously. But the point is he has complete control. Nobody can say boo. Nobody has to yourselves and your loved ones. So let's look at the benefits of revocable living trust. So they avoid, probate, entirely for the trust assets, but you have to put the assets in the trust. You do that by retitling assets. So let's say your name is Mary Jones. We'll prepare a new deed, and we'll deed the house from Mary Jones to Mary Jones trustee, the Mary Jones Living Trust. Get that recorded. We'll show you how to change the name of your assets, change the name of your bank accounts, everything except IRAs. IRAs are a special case. We don't have to worry about IRAs now. They don't go through probate. They have a designated beneficiary. But all your other assets, especially real estate, you can't put a beneficiary on real estate. And we'll see a little later why you don't want to just use the beneficiaries, because you can't keep it in a blood, you can't protect it from nursing homes. So you may need a trust for one of those purposes. The other thing about wills is they get filed in court. Because it's a court proceeding, anybody can go down and look up how much you had, who you left it to, who you left out, how much they're getting, when they're getting it. Not very good. Realtors look at it, financial advisors look it up, and they can take advantage of your heirs. With a trust, because it doesn't get filed in court, it's not a public record. Nobody can look up how much you had, who you left it to. The only people who know what's in the trust are the people named in the trust. The only people's business it is. You have privacy. This is another way of taking back control. And as I said, I mentioned this, my client with the house in Virginia. So if you have a property in 2 states and you die with a will, the will has to be probated in New York, and in this case, and Virginia. So, and I can't start Virginia until I finish New York. So you pay for 2 court proceedings, and they come one after the other. So, it can double, up to double the time. So the next thing about revocable trusts is they can protect protect your if your spouse gets remarried after you're gone. Now, very few people think their spouse, for some reason, getting remarried after they're gone, but it's increasing likelihood because people live much longer than they used to. You know, the average life expectancy has increased by over 32 years since a century ago. So people are living longer, as we know, and they're remarrying, and very often the assets end up with the wife number two or the husband number two, and it never ends up with the children. So the trust allows you to name the children as co-trustee with your spouse and make sure, you know, if something happens to you, the children have to sign off. So if the spouse gets remarried, husband or wife number two doesn't get it. Our overview, actually. We're going to talk about the inheritance trust. We use inheritance trusts. Well, what do you know? We are finally logged in. I think I can pull up my slides now. If you'd be so kind as to bear with me a moment, I will do that. Try to prove that. Okay. Try one more time. Okay. Technical difficulties. Good, good. I trust that you're caught up with me, but I have to now catch up to where we are with the slides. So, drawbacks of wills. Okay, I think we've covered that. Wills have to be probated. Okay, everybody see that? No? They can't, can they see the slides? No? Okay, because I didn't share the screen. That's my bad. I will do that. And share. Just gonna have the yes, you have it now? You have it, but I can't see it. Okay. All right, well, good practice for next time, I suppose. Okay. Can you see? Yes. Can you see the screen now? Okay. So I have my assistant helping me out here, Mrs. Ettinger. So trusts avoid the multiple probate problem. I think that's okay. We talked about remarriage. Okay, good, good. The inheritance trust after both spouses die. Now, let's talk about the inheritance. This is where we were. So why do we use the inheritance trust? Because when you leave it to a son or daughter, if they die before their husband or wife, it goes to the spouse. You know, your son-in-law, your daughter-in-law, they can get remarried, share your assets with a perfect stranger. Well, people today want to keep the assets in the blood. So they set up something called an inheritance trust. And it works this way. First of all, the divorce rate is 50%. If you leave it in a trust, you know that the assets are protected from the children's divorces. So it already makes sense to leave it in a trust. You know, you name your son or daughter the trustee. They're in charge of their inheritance trust. Your plan says, when I die, I leave Bobby's share to the Bobby trust. So Bobby's in charge. He can do whatever he wants, but it's protected if he gets divorced. It's protected if he gets sued, or if he has creditors or debts. So he's in charge, and he can spend the whole thing. So you're not ruling from the grave, but it protects well, the other thing is, you know, you may have a son or daughter. I want to mention this. A lot of people have sons or daughters who are either irresponsible or they are responsible, but they're not good at handling money. So you could protect your son or daughter from themselves by naming somebody else as a co-trustee. Who would you name? Well, a lot of people pick the law firm because, if you pick an institution, they have high turnover and they don't really they're not really warm and fuzzy, and they charge fees, and they don't diversify. They invest with their institution, so you don't really have third-party protection there. So that's the inheritance trust. So the inheritance trust says, Bobby, when you die, whatever I left you is in that trust, and I want it to go to your children, in other words, my grandchildren. And if he doesn't have children, which is, not unusual, it could go back to his brothers and sisters. And if there's no brothers and sisters, go nieces or nephews, but it stays in the blood. Okay, so Bobby dies, he doesn't have children. Bobby dies, he doesn't have children. I'll try to do that. There we go. I think I now know how to do that. Bobby dies, he doesn't have children. It can go to his brothers and sisters, and then it goes to their children, so his nieces and nephews. Now, let's say you're quite fond of your son-in-law or daughter-in-law. In that case, there's a hybrid. You can say, when my son Bobby dies, excuse me, I can't speak now. Can I call you back? Thank you. Let's hope that. That's why I unplugged the phone, and I don't know how to mute it. Maybe my wife will come in and do that. So back at this, let's say you're fond of your son-in-law or daughter-in-law, but you still want to keep it in the blood. Here's what, and I just did this today. Clients very fond. They have one son and a daughter-in-law they're very fond of, so they're doing a hybrid. What they're saying is, when I die, leave it all to the Bobby trust. But if Bobby dies before his wife Mary, and they're still married, then give half to my grandchildren at that time, keep the other half in trust for Mary, give her the income for life, and on her death, give the children the second half. So if she gets remarried, spouse number 2 can't get the assets, they're still in the trust. She gets the income only, but you do something for her. And the grandchildren still get the money, but they get it in 2 installments. So the inheritance trust is very popular. We've done it for, well over 10,000 people since it came out in '98. It's mainstream estate planning. It's more than 20 years old, and I recommend it highly for you. So it's another way of keeping control. You're keeping assets in your family, in the blood, protecting it from divorces, losses, and creditors. Now, the inheritance trust is an add-on to your revocable living trust. So your revocable living trust is your assets, avoids probate, avoids guardianship, and then you could say either you leave it to the children in equal shares, or you set up these inheritance trusts and say leave 1/3 to the Billy trust, 1/3 to the Bobby trust, 1/3 to the Mary trust, and keeps it in the blood. If Bobby dies, who's in charge for his children? His siblings. Mary and Billy. So the money stays in the blood, but the management also stays in the blood. Moving on, this 4th reason, wills do not protect assets from nursing home costs. So, so what if you have a will, you name the executor, have the heirs, the percentages, the nice envelope, calligraphy on the cover, but unfortunately, client had to go into nursing home got everything, the family got nothing. Happens every day. So, what that plan reminds me of the old saying, the operation was a success, but the patient died. Similar. I had an excellent estate plan, except there was no estate left. It doesn't make sense. So how do we protect our assets from long-term care nursing home costs? Plan A, long-term care insurance. Clearly, if you can afford it, if you can swing it, it's the way to go. But the vast majority are not getting it because it's expensive or they get turned down for medical reasons. So we like it. It helps you age in place at home with home care options. Pays for someone to help a disabled spouse, so you don't wear yourself out taking care of your husband or wife. So you get a proposal. If you're insurable, if you're over 70, it's probably too expensive. But if you're under 70, the sooner you get it, obviously the less expensive it is, and you may not be able to get it later. So always get a proposal. So first choice, long-term care insurance. But we're more concerned today with Plan B, the famous Medicaid Asset Protection Trust. The famous trust, you set up 5 years at a time, protects your home and life savings. So you set up 5 years at a time, protects your home and life savings. Now, there's a few misconceptions about these trusts, so let me say what they are. A lot of people think if you put your house in an irrevocable trust, you can't sell it. No such rule. The trust can sell the house. The money's paid to the trust. Trust goes out and buys a condo. You don't start the 5 years over again. Then some people think you lose your exemption. Senior, veteran, star. You don't lose exemptions. What happens is the assessor will call for a copy of the trust to see under the trust who has the right to live there. You have the right to live there, you keep the exemptions. And then finally, some people are worried about the 5 years. Say, well, I'm not sure I can make the 5 years. That sounds like a long time. It doesn't work that way. Let's say you set up the trust, and 4 years later, you have to go into a nursing home. What happens? You only have to pay for 1 year. You already got 4. It prorates, which means it pays to get started, even if you don't make the 5 years. So let's look at the assets that we go in. We place our home. For heaven's sakes, move to protect your home. What happens if you own a home and you end up in a nursing facility? The county puts a lien on it. The lien eventually gets bigger than the house, and the county walks away with the house. Every day, counties all over New York State walk away with people's homes. It's totally unnecessary. For more than 30 years, as long as I've been practicing, you're allowed to take that house, put it into a Medicaid trust. Anytime after 5 years you need care, they can't touch it. It's a no-brainer. So here's how it works. It sets up 3 roadblocks that Medicaid nursing homes can't break through. It has to. It's called an irrevocable trust, but we're going to see you can revoke it actually as long as you and all the children sign. So it's not as irrevocable as it sounds. But you have to name somebody else as the trustee, because the trustee is in charge and the trustee can take it out. So if you have to go into a nursing home and you're the trustee, they say, well, Mary, you can get it, take it out and give it to us. If you could get it, they could get it. So you're going to pick 1 or more of the adult children. You can pick 2 or 3, and usually provide that any of them can act on behalf of the trust. And the other roadblock is you must limit yourself to the income only. And in fact, they're called income only trusts, which means what? You have a CD, you put in the trust, you only get the interest. You have a stock, you only get the dividends. But if you put in your house, and let's see what's on the next slide. If you put in your house, it doesn't affect your lifestyle at all, because you still live in the house, you still use and enjoy it. It's just a different name on the deed, but you pay the taxes and you mow the lawn just like before. But as far as your personal lifestyle, you put your assets in the trust. Basically, you're putting in the nest egg that you don't think you're going to need to spend. So, we ask clients all the time, do you have a nest egg that's non-IRA money? Because IRA, 401k, 403b, teachers' retirement, they're all exempt from Medicaid. So I'm talking about non-exempt, non-IRA money, which is available for the cost of your care. So let's have a nest egg, I don't know, $400,000 or $500,000. A lot of clients tell me, Mike, we don't need that nest egg to live on. We have enough money just in case. It's kind of money just in case. We have enough income, I should say. I said, well, look, if you have $400,000 or $500,000 you don't need to live on, you're actually safekeeping it for the nursing home industry. So why not put it in the trust, still there if you need it, but somebody else can come and take it away from you. So we'll talk a little bit more about the trust. So it doesn't affect your lifestyle. You still get your income, your pension, your Social Security, your IRAs, pensions, etc. So that's not affected. And as I said, it makes sense for assets you're not going to spend like your home, and investments you're only taking the income from because the trust is giving you the income. You have the exclusive right to use and enjoy the home. You keep all your exemptions. And you have control over the trust. You don't give up control. You name your son or daughter a trustee, but you reserve the right to change the trustee at any time. So if they're not acting in your best interests or you have a falling out, you can change them. So the nursing home only gets the income. It protects your nest egg for your children. Let's see what else we want to say about the Medicaid trust. The MAPT. Trust can sell the house, trade stock. So the trust is a legal person, we say. It can buy and sell and trade just like you. There's a 5-year look back, which we said it prorates. It always pays to get started. Look, if you set up the trust and 3 years later, unfortunately, have to go into nursing home, you only have to pay for 2 years. instead of 5. Now, let's talk about the gifting power. So you can't take out principal, because if you could get it, the nursing home could get it. But let's say one day you decide you need $50,000 from that trust to take your whole family and your lawyer on a round-the-world trip. Sounds like a good idea? Well, you can't take out the 50, because if you could get it, the nursing home could get it. But you're allowed to make gifts from the trust to your son or daughter. Because when I apply for Medicaid, they're going to ask me, what did you take out of your name and put into that trust? That's the 5-year look back. But they're not allowed to ask me what the trust gave to somebody else. So you make a gift from your trust, $50,000 to your son or daughter. Now, can they give you back the $50,000? Well, they can't. Because when I have to apply for Medicaid, they're going to ask me to show them all your investment accounts, all your bank accounts for the last 5 years. And if they see 50,000 came out, they're going to say, where did that come from? And if it came from the trust, you're sunk. So they can't give you back the 50. But they can take the 50 and go pay the travel agent for the trip. It's their money. They can do whatever they want. So backdoor, you give them the money, and they go and pay for the trip. Okay, so it always pays to get started. You, if you don't make the 5 years, you only have to pay for the time left. So before we get into our process, let's have a quick review. We use trust, avoid probate on death, avoid guardianship on disability, keep assets in the bloodline, protect the inheritance from children's divorces, lawsuits, and creditors. And then we can also, and of course, the inheritance trust passes it by blood instead of by marriage, gets it to your grandchildren, goes 30, 40, 50 years after you're gone. And finally, the Medicaid Asset Protection Trust. And that protects your hard-earned assets from long-term care nursing home, because most people cannot get long-term care insurance, either because they can't afford it or they don't qualify to get turned down for medical reasons. So now I'm prepared to talk about our unique process. It's trademarked. The seminar, I wrote it, and I will be giving it every Wednesday night at 7 p.m. And I'll work out my technical difficulties. I will not unplug the phone 3 minutes before the seminar starts, I assure you. Lesson learned. We'll get better and better at using technology. So we're going to send you a link tomorrow. We're going to thank you for listening. We're going to send you a link. And if you think this is valuable for your friends and relatives, anybody on your email list, you can send them the email, and they'll be able to register themselves for the seminar. And you're always welcome to join us again and see if we've improved at all in our technical skills. So here's the way Ettinger Law Firm works. We've been doing it for 30 years. We've done now excess of 25,000 plans. We have a free initial consultation, because we want people to be able to come in and get the information without being afraid they're going to run up a bill. You bring in your current documents, your will, your power of attorney, health proxy, living will, your trust if you've done one. We'll review it, and we'll give you a legal opinion. Then we make, if you need improvement, which most people do, we make our recommendations. We tell you, if you go ahead, this is what it'll cost. Somebody asked me one of the questions, how much does it cost? Well, you can't answer that question, because it costs between $750 and $7,500. Depends on a person's circumstances, what they're doing, etc. I don't want to scare anybody off who might need a $750 just a power of attorney. It might be the most important document they ever had. But we will review it and make our recommendations. We have 10 lawyers, and it'll be with one of our lawyers, and in one of our offices, 15 offices across the state. And we give you a fixed fee quote. So if you go ahead, this is how much it'll cost, and you can do it in payments. We have a payment plan. You can use credit cards. And then, you can decide to go ahead, but we actually prefer it. Did you go home and think about it? So I give you a copy. Let's say I'm doing it, but any of our lawyers do. We give you a copy of my book on elder law estate planning, a bestseller. And we say, these are the chapters that apply to you. We want you to read chapters 1 to 6, 20 to 21, whatever it is. And why don't you go home and think about it? Let's meet again in 2 or 3 weeks. So you come back in 2 or 3 weeks, and now we have a follow-up consultation. Review the proposal, answer any questions you have. We draft the estate plan together. At the end of the second meeting, we give you a detailed 2-page proposal in writing. Here's what we recommended last time. Here's the fees we mentioned last time. Now it's in writing. What would you like to do? And unfortunately, a lot of people say, it sounds good, let's go ahead. Now, there's the book, okay? There's a second free consultation, read the chapters, okay? And the fees and, choice, okay. So before we get to the final meeting to review documents, we're going to talk about, so now you said, okay, I want to go ahead. We're going to schedule your third meeting to review the documents. But here's the key. This is unique to Ettinger Law Firm. We pioneered this. I believe we're the only law firm, estate planning law firm, because personal injuries firms don't charge fees until they win the case. But we're the only estate planning firm, to my knowledge, that does not charge any fees until everything is signed. So what's standard in the industry is clients say, estate planning lawyer, I want to go ahead, and the lawyer presents their fee agreement and says, sign here and give us a retainer, usually a check for a half. We don't do that because we want to put you, the client, in control. If you're in control, we think it's the best place for you to be. And if it's the best place for you to be, then by definition, it must be the best place for us to be because you're the client. So we write a fee proposal. It's not a fee agreement. You don't sign it. We sign it. And our fee agreement says this. We're going to go ahead on your say-so. We'll prepare all the documents, trusts, power of attorney, health proxy, living will, the deeds to your properties, a few other documents. But our proposal says, unless and until you write us a check, you have no obligation to the firm. So you come in for your third meeting, review all the documents, assuming you're satisfied, you sign everything, you pay at the end. And you can pay by credit card and installments. We have some payment plans. But the point is, you can get up at that last meeting and say, you know what, I changed my mind. You can walk out the door, you owe us nothing. Because then until you sign your check, you have no obligation to the firm. We actually put the client in control. And this is a breakthrough in legal thinking. No other firm is willing to do something like that. But we found it very successful. And perhaps this is how we ended up with over 25,000 clients. Now, the second thing we do at Ettinger Law Firm is after you sign, we don't say goodbye. The standard in New York, around the country, is after you sign your estate plan, thank you very much, goodbye. In fact, some lawyers even send a letter saying, this concludes our representation of you in this matter. And they send a letter because it starts the statute of limitations running, so that they made a mistake, the client can't sue them. Good for the lawyer, not good for the client. We're not afraid of that. We actually track all our plans for law changes. We don't say goodbye when somebody leaves. We say, hello, you're a client of the firm now. We're going to track your plan, and this is all in writing. In fact, it's trademarked. It's a trademark process. I trademarked it in Washington in 1999, about 21 years ago. So we track all our plans for law changes. If there's a law change that affects you, we'll tell you. You don't have to worry if your documents are up to date. That's quite valuable because most people who come into us have documents that are obsolete. They didn't know it because nobody told them. Nobody's tracking it. Once a week, I publish a law letter. Very easy. You can go onto the website and sign up. The website's trustlaw.com. You can sign up for the Elder alert. Send us an email. Anybody will sign you up, no problem. Once we can get my law letter. Every couple of years, we invite our clients to breakfast, update you on the law, what's happening in the firm. We invite your next of kin, meet the lawyer. Why do we have the breakfast? Nobody else does it because we're building a relationship. We think it has value. And we don't charge for phone calls, emails, or questions, so you can call the firm without worrying about getting a bill. I'm sorry, Muriel. We'll have to call you tomorrow. Thank you for calling. Don't know how to turn off the phone. Another technical difficulty. We review your plan every 3 years. If there's a change in your health, your assets, your family. So let's focus on this for a moment. Do you think somebody can do an estate plan today and hope that it's going to work, years and decades later? Probably won't work. So we think, and we've proven this time and time again, a plan has to be reviewed every 3 years for these types of changes. So it's going to work when you need it, not when you wrote it. Could have been years or say decades earlier. In fact, it probably won't work without this review. And it's free. So you come in, if you have to do legal work, we charge for legal work, but most times people don't need legal work. They just need to make sure everything is the same as before. But the legal work is fairly modest fees. But an Ettinger plan is designed to work when you need it, Not when you wrote it, could have been decades earlier. So we actually saved thousands of people, many, many thousands of problems. And I recommend it to you. And you know, when something happens to one of our clients, we know who it is because we have the breakfast every 2 years, a review every 3 years. We've seen the average client, you know, 8, 9, 10 times. So essentially, what are we saying? When you go to use your plan, I hope many, many decades from now, it's never more than 3 years old, designed to work when you need it, not when you wrote it. And there you go. So, you know, we will send you a thank you. We will invite you to a free consultation. A lot of lawyers charge $500. We don't charge for it, and we have even more experience than most of those lawyers. So it's like a $500 gift certificate. So you have a free consultation. Today, these days, of course, we're doing it by phone. We're doing it by Zoom. They go a little better than this because they're simpler. So we'll work on our expertise, as I say. But, you know, we're starting to get a little expertise with it, and we're enjoying it. And, you know, it's nice to connect with people. And it's a free consultation. There's no obligation. And we'll show you how to get that tomorrow. So it'll be with one of our 10 experienced lawyers. These days, it's not in the office. We're not open yet. That's the law. When the governor gives us the okay, we'll let you know. But right now, it could be, and we can't go to your home either, but in ordinary times we can. But these days, we do by phone and video. You have, if you printed this out, you can call Patty or email her or text free C at this number. And again, you'll get the opportunity to do that in the follow-up email tomorrow. And lo and behold, we're done with that. And so, let me see if I can pull this back up. Okay, so where do we go from here? I want to make sure I have a lot of excellent questions this week. I want to go over those. And I want to make sure I have touched on any issues. I had a client, I wanted to tell you this story. I had a client who said, you know, his parents had a trust. This was just recently. His parents had a trust, and he was so happy. In Saudi, he said, you know, Mike, he said, the crap show didn't happen. Me and my brother still talk to each other. Isn't that nice, you know? Do you know that so often after the will is settled, you notice, like brothers and sisters, they never talk to each other again because they've been fighting over the estate for 2 years. You know, I can settle a trust in 2 months instead of 2 years. It makes a huge difference. It keeps the family together. I just want to mention they've changed the look-back period for home care. So to go into a nursing facility was a 5-year look-back. For home care, there was no look-back. You know, you transfer the assets. Next, if you need home care, you know, you transfer the assets. The next month, you apply for home care. Today, there's a new law. It takes effect October 1 that says that there's going to be a 2.5-year look-back on home care, which means what? You got to set up your Medicaid trust and get that 2.5 years. So if you need home care, you're not starting from that point and having to pay for yourself for the 2.5 years before you're eligible. So now the Medicaid trust has become much more valuable, and it also protects your assets from debtors and creditors. So if you're running into a financial problem because of the pandemic, this is going to protect your assets that you put into that trust. I want to mention next week, I'm going to give a talk on, I'm going to call it Creating an Estate Plan in 5 Easy Steps. I'm going to talk about the 5 easy steps to create an estate plan. I think you're going to find that quite interesting, and I hope you'll join us next week at the same time. And so let's go into some of these very interesting questions. Here's somebody, this is Anna Maria B. Her husband must be Andy, because it's Ann and Andy in their email. And she had an irrevocable trust. She has some investment property. You know, she has, wants to know if she can deduct the amount of the trust it paid for taxes. Well, if the trust pays the real estate taxes, you can't get the deduction. But if you pay the real estate taxes on the property and the trust, you can get the deduction. So that's important. But in terms of any expenses, you can pass those expenses through to the individual return. and your accountant will know how to do that, so you can take the expenses. And basically, you tell the accountant it's a grantor trust, and the accountant will know what that means, and he'll pass all the gains and losses from the trust to your personal return. And you can give him our number, and he can call any of us here at Ettinger Law Firm, and we'll answer any questions the accountant has. ML Demaskinos, I don't know your first name, but thank you for your kind words last week and this week. You're very, very nice. And I thank you for that. And same thing with Esther L. I appreciate your comments. So Esther asked me, can somebody challenge her power of attorney that was prepared by Ettinger Law Firm? Very, very difficult to challenge a power of attorney because they have to prove that you were under undue influence, that somebody pressured you, or that you didn't have your marbles. And try to go and prove somebody didn't have their marbles years ago, you have to hire a forensic psychiatrist, get medical records. Extremely difficult, and also we're experienced firms. So that's also going to tend to hold up because we're known to know what we're doing. So I would say very, very difficult, not something I would even be concerned about. You know, if you're concerned about a particular person, call me and we'll talk about it. But I have to say, I was a litigation attorney for 10 years. Before the 30 years, I was the elder law attorney. And so I'm not really afraid of these types of matters. And I can probably talk you out to the ledge or tell you not to be concerned about this particular person you're concerned about. They won't be a problem for us to deal with. Now, Esther also had a second question. You know, do you need both a revocable and irrevocable trust? Well, no, you don't need both. And here's why. If you do an irrevocable trust, you got to put most of your assets in or it's not going to work, right? I mean, if you leave out $400,000, what's the use of the trust? You're going to be paying a nursing home for the close to 5 years anyway. So we say if you set up the irrevocable trust, you're putting most of your assets in. You might leave out 50, 100, even 200,000, but that's not a reason to set up a revocable trust. On the money you leave out, you can just put beneficiaries or make a joint, so there's no probate goes to the person you want to get it. Frank C. says, can a beneficiary refuse to take a bequest? Yes, absolutely. And can a beneficiary terminate the trust and just get the assets? Well, generally, yes, depending on the circumstances. Somebody here, Robert G., wants to know the limits of gifting in a tax year. It's still $15,000 this year in 2020, but it's indexed to inflation. So next year it might go up to $16,000. Depends on the consumer price index. Here's a question. Stephen M. wants to know, if I set up the trust here and I move to another state, is the trust good in the other state? Let's say North Carolina. Yes. If a trust is valid in the state you created, it's good in any state. But if you move to South Carolina, let's say, you might want to get the local power of attorney healthcare proxy, because if you're dealing with, you know, medical facilities, you're dealing with doctors, or you're dealing with banks or investment houses, you want to look like a local. You want your North Carolina documents. You don't want to give them your New York documents, which they may not be as familiar with. They're legal, but they could still cause you some problems. So I say, yeah, the trust is good, the estate plan is good. Maybe redo the power of attorney health proxy if you permanently reside in another state. Moving on, these interesting questions. So, you know, this is Janet L. Janet says, you know, what's the minimum estate value to set up a trust? I've been asked this so many times. There is no minimum estate value. It depends on the circumstances. You know, we've had many, many clients over the years. They just have a house. They don't have a lot of assets, but they have a house. Well, if you ever go into nursing home, you don't have a lot of assets, you're going to lose the house. So they set up the trust to protect the house, and that's means everything to them. So it depends on the circumstance. There is no minimum for a trust. Now, Suzanne R. says, what are the advantages of leaving assets to grandchildren rather than to child? There's one child, 3 grandchildren. Well, there's no advantages to leaving assets to the grandchildren. It's just a question of taste. But we have to consider, and this is why we like to have a meeting, you know, and talk it over. You know, is this going to be resented by the, I don't know if you have a son or a daughter, but how are they going to feel about it? If you want to do that, maybe you want to run it by them so they're not caught unawares. Or you may have good reasons for doing it. It's the type of thing we talk about. And you want to get the pros and cons and, get the attorney's judgment, through thousands and thousands of cases. What have other people done in your circumstances? Why did they do it? What are your options? So I would say, let's talk that one over before you do it. This fellow wants Mr. G wants to have his girlfriend inherit his condo. Well, there's three ways. You can put a joint on the deed. Maybe you don't want to do that because you can't take her off if the relationship doesn't pan out. But you can leave it to her in a will because you can change the will at any time. You can set up a trust, and in the trust say, when I die, it goes to her. You can change the trust anytime, but obviously we know the trust avoids the probate. I talked about costs for Cy. Here's a question from Marcia S. What happens to our pension if New York has to declare bankruptcy? I'm just a lawyer. I don't know, and I hope it never happens, and it's outside of my expertise. I can't imagine such a disaster occurring. So here's a question from James R. There are many instances where you pick a child or a close relative to be the trustee, but what if we don't have anybody who fits that mold? Either the son or daughter is not capable, not willing, is estranged, don't have children, a whole host of circumstances. So in my view, the estate planning firm is the best choice, because if you hire an institution, they have high turnover. You never know who's going to be looking after the account, and they're not warm and fuzzy. They are very somewhat dispassionate and businesslike. But also, if I pick Bank of America as my trustee, well, they're going to invest with Bank of America, which is actually Merrill Lynch, but they're only going to invest with their own company. So I don't have diversity. They're not going to go somewhere else. They're not going to shop around to get me the best deal because they're the trustee. They're going to invest with their company. So you lose some diversity there. Can I put, this is Leo B, wants to put his mature EE bonds into the trust? Absolutely. We have forms with the Treasury to do that. So yes, you want to protect them from long-term care, put them into Medicaid Asset Protection Trust. We know how to do that. Then I have Liz D, wants to know about protecting assets from other family members if one of them passes away and they are in a same-sex couple for 11 years. They're not married. They each have homes in 2 different states, New York and Delaware. Looking forward to learning more. Well, Liz, I wrote a chapter in my book, but it's also on my website. If you look under practice areas, look at estate planning for same-sex couples. Fleshes out all the issues, and after you read that, if you want to schedule an appointment, we can talk it over. But I think you'll get some insights. There are a lot in common. Married and not married, same-sex couples have their own issues. Sometimes with disapproving other family members. So you want to make sure that if it's your partner you want to handle your affairs, if you become disabled, you give them the legal documents and prevent the wrong person from getting it. Now, here's a nice question from Margaret F. What are the consequences? I have a condo in New York and one in Virginia, and what are the consequences of putting them in both the parents' and children's names? Well, not a good idea, I'm afraid, Margaret, because when you put your son or daughter's name on the deed, you're subject to all their debts and liabilities, divorces, lawsuits, creditors. If they get into a medical problem, they have to declare bankruptcy, your property is in play. So you're exposed to all their risks, their debts and liabilities. So not something I would do. You decide to sell it and they don't want to sign or they don't agree, you can't sell it. You gave up control. They're on the deed. And then there's the tax ramifications. So you lose the benefit of something called the stepped up basis. And the stepped up basis works this way. When I die and I own a property or a stock, the basis, which is what they use to calculate the capital gains, the basis gets stepped up from what you pay to the date of death value. So let's say you bought a house for $200,000. When you die, it's worth $500,000. The kids get it as if they paid $500,000. So they pay $500,000, they sell it for $500,000. No gain, no capital gains tax. If it's joint with them, the law says they only inherited half. So they won't pay the capital gains on the half that they got from you, but the other half, which they already own, they'll pay the capital gains tax. So you lose half the benefit of the capital gains. This is called the stepped up basis, the new capital gains. Okay, here's someone complains that institutional trustees are typically unresponsive, cold, and impersonal, and they charge a lot and they're accountable to no one. That's for sure. That sometimes they churn accounts and as a high turnover. Exactly what I said. That's very good, Ed T. Any other abusive solutions? Yes, we act as trustee on many trusts, and it's very successful. People really like having their attorney, and we have backup attorneys. We have attorneys in, I'm in my 60s. There's attorneys in our 50s, 40s, 30s, and 20s. We actually have a succession plan at Ettinger Law Firm, so there'll always be an attorney to continue that, no matter how long it goes. Here's a question from Alan Z. He has a trust. His parents set it up. It's in perpetuity. He has a son who may need a special needs trust. Your situation is complicated. I need to see that trust, see if we can undo it, see what the issues are. But I did write a chapter in my book on special needs trust. It's also on my website under practice areas. You go to trustlaw.com. I'd like you to read that chapter on special needs trust. And if you like, call and make an appointment, or email and make an appointment. I'm happy to talk to you about the details. For Lucian M, we did send you an email. You have a phone number you can call in, so I hope that worked out for you. Maureen W says, how can I leave a Brooklyn co-op apartment as a trust to my son? You have to ask the co-op, Maureen. About half the co-ops allow a transfer to a trust and half don't. Hopefully you're one of the half that does. It's a policy of the co-op. If they allow it, we can put it into the trust. Not a problem. Here's from Pierre L. Pierre wants to know, can he name trustees in Quebec? I'm born and raised in Montreal myself. And so the answer is yes, you can name trustees living in another country. Trust is a private agreement. It's between you and them. So you can pick a trustee who lives outside the United States. Not a problem. So here's a question from Joan B. I would like to know whether it's better to sell our house to our daughter or place it into a trust. Well, that's a tough one. I need to have a consultation with you, Joan, because there's a lot of pros and cons for selling to your daughter versus placing in a trust. And I have to get a lot more information from you. And I'll be happy once I get the right information to give you an opinion on that. Is money in trust exempt from state and federal estate tax? Well, the New York State exemption is $6 million. And the federal exemption is 11.4 million. New York is actually 5.85 million, but close enough to 6. So almost everybody's under that, so you don't have to worry about the estate tax. Of course, with what's going on now, we know that there'll be pressure to lower those exemptions. But if you're a client of Ettinger Law Firm, or you subscribe to the Ettinger Elder Alert, which you do right on the website, then not a problem. We will tell you if they change the estate tax exemption, just like we would tell all of our clients. Question from Gary T. I live with my dad. The deed is in dad's name. What happens when dad dies? And I have a sibling, brother. Well, if dad had a will, it goes according to the will. If he had a trust, it goes according to the trust. But if he doesn't have a will and he dies, there's a statutory will. And the law says, the statute says, if somebody dies without a will, they don't have a spouse, they have 2 sons, it goes in equal shares to 2 sons. But you have to go to court in an administration proceeding to get it, just like a probate proceeding. but it's called an administration proceeding. You don't have to prove the will, but you have to go to court and get appointed. Instead of being appointed executor, you're appointed the administrator. It's called an administration proceeding. Here's a question from Karen H. It says, Karen's remarried. She has 4 sons from a previous marriage. She was left an inheritance by her mother. What's the best way to protect it for her heirs and use it during retirement? Very simple, Karen. You put in a trust, and you can put other assets in the trust, and you say, when I die, these assets go this way, and that assets goes that way, so not a problem. You know, a lot of times in second marriages, clients will want to leave some of their assets to their children specifically, and some of the assets to all the children, you know, the combined marriage or any combination of that. So yeah, the trust will do that for you. Here's a question from Sharon B. Should I consider paying off my mortgage during the volatile market? They're 73, they have an inheritance, they were thinking about paying off the mortgage. This is not a legal question, this is a business decision. You discuss it with your accountant. But you know, not everything has to do with money. It could be a peace of mind decision. A lot of people say, you know, the accountant's telling me I get a deduction, I can lose the deduction. You know what, but I would feel better if it was paid off. I don't want to have that bill hanging over my head. And so sometimes the peace of mind is worth more than the money. And you do it even though it's not the best tax decision. Not everything is about taxes. And finally, I'm going to look and see if we have questions online. But George M. says, he wants to set up his trust. We want to add assets later. No problem. You can add assets later. You don't need the lawyer. We'll show you how to do it. You'll know how to do it. When you add assets to an irrevocable trust, you know, a Medicaid trust, it's 5 years on the new money, right? The old money is running on the 5 years when you put it in, but you put in new money, it's 5 years on the new money. But you can do that yourself. You don't need the lawyer. Okay, my microphone is fine, very clear. Thank you, Joe. I appreciate that. I'm just looking at my questions now. That were posed online, about 20 questions. If you want, please stay with us and I'll answer them. Does designation of beneficiary over a will, does designation of beneficiary override a will or trust? Yes, a beneficiary overrides a will. It doesn't override a trust because if you put an asset in a trust, the beneficiary automatically comes off because the trust has the beneficiary. So it overrides the beneficiary in the will, yes. The designation of beneficiary overrides whatever you said in the will, but not the trust. Frank F. has another question. If accounts and property are jointly held, does the property and bank accounts automatically go to the joint party? Correct. That's exactly what happens. Automatically passes by operation of law. Don't have to do a thing. But they may want to present the death certificate to the institution or whoever to take the deceased person's name off the account. What's the difference between putting assets in a trust or LLC? Well, an LLC doesn't have a plan of distribution and a trust does. So an LLC is done for asset protection, but it's not an estate plan. And a trust estate plan, it can be done for asset protection instead of an LLC. So we'll have to discuss that. Please put your slides up, okay? I did what I could on there. Mom, here's E&S. Mom's beneficiary. Mom has a Roth IRA. Dad is primary beneficiary. Okay? No, there was no question there, so I can't answer. Do you have offices in Northern Virginia? No, but let's say you're looking for an elder law attorney in another state. Take down this acronym, naela.org, naela.org. This is the website of the, type your question, Don, and I'll get to it. This is the website of the National Academy of Elder Law Attorneys, and you can search by zip code for all the elder law attorneys, and you can scroll out. You can search for the elder law attorneys within 5 miles of that zip code, within 10 miles of that zip code, within 20 miles of the zip code. So go to naela.org, National Academy of Elder Law Attorneys website, and you can find a good elder law attorney there. Do all wills have to go through probate court? No. Only if there's assets that have to be probated. What assets have to be probated? Assets in the deceased person's name alone. So if the asset was joint, it goes to the beneficiary. If assets were joint, it goes to the surviving joint owner. If asset had a beneficiary, it goes to the named beneficiary. But if it had no beneficiary and it's not joint, then it's in the deceased person's name alone. It has to go through probate to get it to the heirs. Next question. This is ENS again. Oh yeah, here's the rest of the question. Okay, show it up again. Mom has a Roth IRA, dad's the primary beneficiary, and vice versa. Son is the beneficiary on the irrevocable trust with grandma's IRA assets. Can he be named a second beneficiary on each of the parents' IRAs for asset protection purposes? Absolutely. What happens is the IRA goes to the surviving spouse, and the spouse has to designate a new IRA. It's a rollover, and has to designate a new beneficiary because dad dies, it goes to mom. They're going to say, Mom, who do you want to leave it to? And she'll indicate that she wants to leave it to you. But if dad predeceases mom, the IRA or Roth can say, yes, I named my spouse first, my son second. So no problem with that either. Steve C, okay, 401k, same as IRAs, yes, correct. It's still protected from Medicaid. Joint bank accounts, yes, the surviving spouse has access and control immediately upon death, no problem with that. Michael and M, is there a 5-year look-back period for money put into an IRA? Well, this is not a transfer, actually. It's your own money. So you're not giving it to somebody else, so it's still yours, and it's an exempt asset, so there's no look-back. No problem. Here's Ed is still looking for my Northern Virginia office. I do have 15 offices in New York, but none in Northern Virginia, fortunately. That would be difficult, but again, go to NALA, and I think you'll find what you're looking for. Can you hold original documents in your safe protected? These days, we actually scan all the documents into the computer, and we have digital copies. You can reproduce it at any time, and the computer, is fire. We don't have to worry about fire and whatnot because it's in the database. So this is what people do. Everything's digitalized today, and if you want a copy of trust, just we can send it right to you. It's already in the computer. All the signed documents. So we give. So this question is also: do we keep the originals? Now, a lot of clients, a lot of lawyers keep the original documents. They say, we'll keep those for safekeeping. Here's the copies. Why do they do that? Well, they do it because this way, you have to go to the lawyer whenever you need something because they have the original. I don't like that practice. I don't think it's fair. I know why lawyers are trained to do it because it gives the lawyer control, but we don't want to have control over you. So we want you to have control over yourselves. So what we do is we give you the original, we keep the copy. And we work hard to make sure you want to come back to us instead of forcing you to have to come back to us. We think it's just a more enlightened approach. I am single. Regina D says she's single, never married, no kids, owns a condo. What benefits are there for me with a trust like this? I love this question because your biggest risk, Regina, is if you become disabled. It happens to happen to all people. Don't you want to know who's going to handle your affairs if you become disabled? Don't you want to pick that person or two people? So with a trust, you're guaranteed, it's ironclad. You're going to get the person you choose. Without a trust, it could be anybody. The state could appoint a legal guardian, or the wrong person can get in. So if I'm single, I feel more vulnerable. I want to make sure that my people are going to get in charge if something happens to me. And so we find singles are more vulnerable and need a trust for disability more, even than married people. What if you have a property in LLC? This is Jackie G. What if you have property in LLC and both myself and husband are members of the LLC? I take that LLC interest, I put it into the trust, and now there's no probate for the LLC. Carol L., if I move to Colorado, can you still help me legally? Again, go to NALA.org and you get somebody. I have a friend in Boulder, a good estate planning lawyer. If that's where you're going, I can help you with that. I have a trust where the distribution is over a 10-year period. What would the cost be if you were to administer the trust? Distribution would be at time of death, 5 and 10 years later. We get a 1% fee to act as trustee. I do. 1% a year. Comes out of the income. I gave my daughter and son-in-law quite a bit of money to buy their house. I get considered a gift, so should I file the gift tax? This is Carol S. How will the IRS know if I gave it as a gift? Well, Carol, if you get audited, they're going to see that all this money went out of your account because they'll see your bank accounts or your investment account. They'll say, where did it go? And if you didn't file a gift tax return, well, there's penalties for that. But the gift tax return, there's no gift tax. You can give up to $5,800,000. Actually, I take it back. New York doesn't have a gift tax. So federally, you can give up to 11 million tax-free. So 11.4 million. So you have to file a gift tax return, but there's no tax. They take it off your 11.4 million at death. Not really a problem. So just have your accountant file a one-page return. I made the gift. There's no tax. It's no issue at all. Joseph A. Okay. It's a little bit long. I'll try to summarize. He has no legal documents. He has investment properties in New York and places in Atlanta, working full-time. Has long-term care insurance. Spoke to Mrs. Ettinger about a year and a half ago at a seminar. And she had maybe at that time, because of your age, she felt you could get by with a will. You don't need a trust yet. Will trusts maybe start around age 60. But with property in 2 states, you may want to reconsider a trust because if you die, there's the 2-state probate. So yeah, why don't you set up a consultation? It's free, it's low key, and we'll talk to you about it and make some recommendations. And what happens is you just request a consultation. My firm will send you the form to fill out, or they'll direct you how to do it on the website, and we get the information, we make the call, and we answer your questions and give you our legal opinion. Stephen G says, can trustees who get the parents 3 properties on death retitle the properties into an LLC or limited partnership? Of course. And the trustees don't have to sell the properties. You can retitle them into an LLC or limited partnership right from the trust. You don't have to do 2 deeds. There's no problem with that. Ron M. If I only have a will and become disabled, doesn't my wife automatically become my legal guardian rather than the court appointing one? No, your wife does not become your legal guardian. And in fact, your wife may be incapacitated herself or may not be capable of being legal guardian. No such thing. A lot of people don't even like their spouse. They don't want their spouse. So we can't have that automatic. A lot of people think, well, it's my wife, they can sign for me. Your wife can't sign for you. Can't make medical decisions for you. Can't, you have to have legal, give them legal authority. But generally, if you have a spouse, you don't generally end up in a guardianship proceeding. Guardianship is usually people who the spouse is either disabled or the spouse is passed on. Ralph G. If I have a will and a trust, can other sibling family members challenge the will or have access to the will and trust? Well, look, it's much easier to challenge a will than the trust because the will goes to court, a notice goes to the other heirs, or even people are left out, asking if they agree to the probate. If they don't agree, they just check a box and you're into a will contest. With a trust, it's very, very hard to challenge a trust because courts will give a trust more respect than they will a will because they feel that if you did a trust, you're probably more sophisticated, knew what you're doing, you were an estate planning lawyer. Trusts are harder to challenge, and lawyers also don't like to challenge trusts. And the reason lawyers don't like to challenge a trust is because if a lawyer challenges a will, the whole proceeding stops, and the legitimate heirs have to go to the lawyer for the illegitimate heir and say, well, what will it take for you to go away? Because nobody can get their share until the will contest is decided. So the lawyer for the challenging heir has procedural advantage. He's holding all the cards. Nobody gets anything until they deal with him. But it doesn't work that way with the trust. It's not in court. So when somebody challenges the trust, the assets have already been distributed. You can't stop the trustee from distributing. It's not a court proceeding. So what happens is the lawyer has to start running after the heirs, like chasing the horses, after the barn door's been left open. Nobody wants to do that. So lawyers don't like to challenge trust. It's difficult. They have to find the assets. They have to sue the heirs. And then the judges will probably uphold the trust, especially if done by an established elder law firm. Patricia F., what's a pour-over will and who needs one? Good question, Patricia, or Pat, or Patty, however you like to be called. Pour-over will goes with every trust. Every trust needs a pour-over will because the pour-over will says it does 2 things. First of all, you may have an old will out there. So the pour-over will, being a later will, cancels the earlier will. So you can forget about any old will you may have outstanding. But the pour-over will says, in case I left something out of my trust, pour it in there after I'm gone, because my wishes are written in the trust. So in case there was a loose end, you forgot something, you left something out, you missed something, this will put in the trust because your wishes are written in the trust. Rachel R., you keep referring to the 5 years regarding to the Medicaid Asset Protection Trust. The map, can you explain what that meant? Sure, Rachel. When you set up a Medicaid trust, you can't put your assets in the trust and the next day show up to the nursing home and say, I'm here, take me, I don't have anything. The state can look back up to 5 years on a transfer. It's called the look back period. So if you transferred assets more than 5 years ago, they can't touch it. If it's less than 5 years ago, let's say it was 3 years ago, you're not eligible for Medicaid until the 5 years pass. So you got to pay for the last 2 years, then you can apply. Because the question on the Medicaid application is, what if you transferred within the last 5 years? You have to be able to say nothing. You're not eligible. You can't apply. So you got to get past the penalty period. And that's what we're talking about. Jorg K., do you need a Medicaid trust if you have a reverse mortgage? Well, if you want to protect the equity above the reverse mortgage, the answer is yes. What is the difference between and you also avoid probate? Marion G., what is the difference between an inheritance trust and a trust established in your will? Well, a trust established in the will has to go to court. An inheritance trust is usually doesn't have to go to court because you named it as beneficiary of your living trust. We prefer not to have trusts and wills because you have to probate the will, and the judge doesn't just take control of the will, he also takes control of the trust because the trust is under the will. So courts have certain rights over that trust that they wouldn't have if you did a living trust. Matthew L., how do you get things going with the quarantine still active? We actually have done a lot of powers of attorney, wills, trusts by a very simple procedure. It's all done by Zoom, much easier than putting on a seminar. But we actually just did a memo today and we finished it. And it answers your question, how we do the signings with the quarantine. I'll ask Patty to send you that memo tomorrow. Patty's our director of client communications, and Patty will send everybody on the call today how to do your estate online, and it's quite easy. So thank you, Matt, for the question. Ralph G., what do I gain or lose if I set up a DBA versus setting up a subchapter S? I think that's much more of a question for the accounting. I would say it's an accounting question, and I urge you to see your accountant about that. Leonard W., can a tax-deferred annuity that you no longer contribute to but take RMDs be placed in an MAPT? Well, if it's IRA type money, it's exempt from Medicaid. If it's non-IRA, yes, we can put it into a Medicaid trust and protect the non-qualified, the non-IRA annuity. Do it all the time. Iris B., does nursing home only get income from the trust? What does that mean? Yes, they only get, if it's a Medicaid trust for past 5 years, they get the income, interest, and dividends. That's all they can get, whatever it earns. Ralph G., if I have my spouse as primary beneficiary, should I name my revocable trust with its terms, but where assets goes to contingent? Well, no, Ralph, because your spouse could be disabled. Who knows? We always set up the trust for the couple, and it goes to the heirs after the second spouse dies. So if the first spouse dies, nothing happens. So you're taking a big risk by naming your spouse the beneficiary because now it's out of the trust, and I have to be a probate when your spouse died. So we set up the trust for both of you. But maybe you're trying to get at something else, and if you do, set up a phone consultation with us, and we'll take care of that. What do you do with smaller assets such as $15,000 cars, Steve Ann? They don't go into the trust. They don't go through probate either. Cars up to $25,000 they'll get probate in New York. They can get transferred right to the next of kin with a death certificate at the Department of Motor Vehicles. Debbie E., if all my accounts are in trust for my children or beneficiaries, do I have to put some accounts into a trust? Well, if your accounts are in trust for your children's beneficiaries, you avoid probate, but you don't keep it in the bloodline, inheritance trust, and you don't protect it from a nursing home. So consider if you want those protections And if you do, talk to us about it. Iris B again, I recognize you there because you asked a question before. Can you take money out of the trust to pay health insurance, homeowners, car insurance? Revocable trust, you can take out whatever you want. Irrevocable trust, limited to income only. But if the house is in the trust, you're not taking it out to pay homeowners insurance. That's a trust asset. It's a trust bill. So homeowners insurance you can pay from the irrevocable trust, but personal stuff you can only pay from the income because you only allow the income. Ralph G. When I die, I have a state document in my safe deposit box. Will my spouse or children be able to get the safe deposit box? No, they won't. So, Ralph, what I suggest you do is they shouldn't be in the safe deposit box. Nobody can do anything with your estate plan. It's not like money. It's not an asset. So put it somewhere in the house and make sure everybody knows where it is and make a copy. Put that somewhere else. If it's with us, we have a digital copy. What a client suggested to me, which I think it was quite clever once, was they put the safe deposit box in their son's name and they named themselves as the deputy. So if they die, the son owns the box, so they don't close it. And as the deputy, they can go into the box anytime. So consider that. It's a kind of a neat trick. You make the son or owner the son or daughter the owner, you're the deputy. Debbie E. If all my accounts are in trust for my children, are they beneficiaries? Yes. Yet, okay, I think she meant if all our accounts are children are beneficiaries, do we need to put them in the trust? I would say if you want to keep it in the blood, you want to protect from nursing home, put it in the trust, but if those aren't issues, then you can name it directly to them. Carol G, can you make up an irrevocable trust for my residence in Georgia? That's where I live full time. Carol, thank you for asking. Go to NAELA, NAELA.org, and find an elder law attorney in Georgia, wherever near where you are. Ralph G says, should my 39-year-old son get a will, trust, power of attorney, health proxy? Absolutely. He's in Illinois. If he's in Chicago, I know a good elder law attorney and estate planning lawyer in Chicago. I can refer you. Otherwise, he can go to that website and he'll find a lawyer who can do that for him. Yes, 39-year-old should have a will, trust, and power of attorney and health proxy. Well, he should probably have a will. Probably doesn't need a trust unless exceptional circumstances, but certainly needs a will, power of attorney, health proxy. Jackie J. Jacqueline, what happens if your trustees die before you? Well, you have backups. So you have to have a successor trustee. And if you run out of trustees, the lawyers at Ettinger Law Firm act as the final trustees, so you don't end up with no trustee. Daniel L, just a note, about 50% of the sound was missing on the PC transmission, and the picture froze. Okay, I'll pass that on to our people. It was interrupted on an Android cell phone. Okay, we'll look into that. Can a 401b TDA be incorporated into a Medicaid trust? The 401b, I believe, I think it's a 403b, and it's exempt from Medicaid. So you don't need to put it in the trust. And it's exempt from probate. It has a designated beneficiary. Is Rockland currently proceeding on evaluating applications for Medicaid? Daniel, yes, I believe they are. The Medicaid offices are open in the state as an essential service. We're handling a lot of Medicaid matters now, and we do a lot of Medicaid work at Ettinger Law Firm. That's what elder law attorneys do. Ralph G, if there is no healthcare proxy, is help if my spouse is approved for HIPAA, the medical privacy law, so my medical information can be passed along to my spouse. Yes, that'll allow your spouse to get access to medical information, but you should get a healthcare proxy. Can a limited partnership and corporation be placed in a trust? Absolutely. John W, no problem with that. Do it all the time. Carol G, again, the question about beneficiaries as opposed to trusts, or if you want to keep it in the blood, a beneficiary doesn't do that, or if you want to protect it from nursing home. If those aren't your issues, you can go just with the beneficiary. Jean D says, I'm the executor of a trust where the money is supposed to go to a college. They do not want it until it goes to the state. Why? I don't think I understand the question. I'm sorry. I will move on. Carol says, K, how do you protect your cash from Medicaid? I want to put my home in an irrevocable trust. You transfer the cash into the name of the trust. Not a problem. And similarly, can your trust allow you to live in the home? Absolutely. Keep your all exemptions? Absolutely. And that's generally the same in all states. And the trust can sell the house and buy another house. Um, uh, and you have an elder law attorney in Georgia. She never did an irrevocable trust of the house in it. That's because Georgia may be like Florida. I don't know Georgia law, but in Florida, you don't have to put the house in the irrevocable trust because in Florida, they have the homestead exemption and it's protected from Medicaid. So maybe Georgia follows the Florida rule, which is the house is exempt, as opposed to the New York rule, which the house is available. So thank you for those 135 people. We had over 200 people on the call today, and it's very gratifying. I hope you tell your friends and relatives about this, and they can tune in next week, either to the Zoom side chat, or if they're interested in the seminar, we'll do a seminar next Wednesday at 7 o'clock. 135 people stuck through the whole thing. I guess, you know, that's very, you know, it's very encouraging and heartening, and it helps me want to do these things more often and provide more and other information in the future. So thank you for your patience with all the technical difficulties. We're getting a little better. We got a new microphone. It's clearer. I won't unplug the phone next time. Practice, practice, practice. And again, thank you for listening, and wish you all the best. Thank you, and have a good evening.